My name is Professor Matthew Rimmer from the QUT Faculty of Law in Queensland, the Sunshine State in Australia. I'm very honoured and privileged to join you at the Gonzaga Law School to discuss emerging trends and patterns in relation to international trade law. My presentation today builds upon a recent publication that I co-edited with Professor Mark Lemley from Stanford Law School and Danusha Mendez from Bournemouth University. The work is called 3D Printing and Beyond, Intellectual Property and Regulation. It looks how 3D printing has disrupted various different species of intellectual property like copyright law, trademark law, patents, designs and trade secrets. It also looks at how 3D printing disrupts regulatory frameworks across a wide range of different areas. My presentation today builds upon that edited collection. So I'm arguing today that not only does 3D printing disrupt intellectual property, it also unsettles international trade law. So my talk today, ClearCorrect, Intellectual Property, 3D Printing and the Future of Trade, really explores some of the intersections between intellectual property and trade, looking particularly at some instances dealing with 3D printing. This builds upon some of my past work. So previously I've done work on digital copyright, gene patents, access to essential medicines, plain packaging of tobacco products, intellectual property and climate change and Indigenous intellectual property. Many of these fields have raised larger questions in relation to intellectual property and trade. So my interest in the topic partly stems from an engagement with those topics. To begin with, I'd just like to deal with a kind of a prologue, kind of starting a conversation about the regulation of 3D printing. The hit HBO series WESTWORLD has provided a useful metaphor for some of our anxieties, concerns and fears about 3D printing and bioprinting. The Nolan TV series starts with a very arresting trailer with a pianola being played as various different individuals and animals, 3D printed and bioprinted. The series, amongst other things, has a very kind of strong theme looking at intellectual property. So one of the characters notes at one point, do you know how far these people will go to protect their intellectual property? But I think WESTWORLD is a kind of a good metaphor for the debate over the regulation of 3D printing because it is a bit of a Wild West at the moment. It's not just courts and parliaments and international institutions trying to regulate 3D printing. Battles play out according to social norms and market forces, and a lot also depends upon the technology as well. So there are certain echoes of what happened in the 1990s with the advent of the internet and John Perry Barlow's declaration of independence of cyberspace. But my presentation today is going to be focused upon some of the recent developments in relation to 3D printing and some of its real-world applications and how that affects questions about intellectual property and international trade. So historically, the International Trade Commission has had a role as a US federal agency and has broad investigatory powers to look at a wide range of different trade issues in the United States. For a long while, one of its areas of interest has been matters of intellectual property. In my previous work, I highlighted some concerns in the intellectual property community about the role played by the International Trade Commission in some of the disputes over intellectual property. In my work on clean technologies, I kind of noted that there had been complaints by some that intellectual property trolls or non-practicing patent entities had used the International Trade Commission to stop the trade of certain intellectual property goods. This particular dispute, in some ways, really started off as part of a larger clash between early adopters of 3D printing. So Align Technology Incorporated, which is the maker of the Invisalign dental system, claimed ClearCorrect Operations LLC infringed its patents. It asked the International Trade Commission to block ClearCorrect's transmissions of computerised dental plans from an office in Pakistan to a 3D printer in the United States. And this dispute went through a number of stages of litigation. Initially in 2013 and 2014, the International Trade Commission held that the Commission had a jurisdiction in a dispute in respect of patent law, 3D printing and electronic transmissions. The International Trade Commission took a broad view of its jurisdiction and said that there was an industry in the United States that exploited a number of patents. The Trade Commission held that the accused digital models, digital data sets and treatment plans for use in making incremental dental positioning adjustment appliances and the appliances made therefrom and the methods of making the same infringed a number of patent claims. There was an appeal against this ruling. Scott Grunwald hoped that the Court of Appeal for the Federal Circuit would address how patent law would apply to 3D printing. He said that the federal courts are about to decide exactly how patent law will be applied to digital representations of real-world objects or 3D digital models. Some academics at that point took an interest in the dispute, so Lucas Osborne in particular was very kind of focused upon how this dispute would be interpreted, both in terms of the International Trade Commission, but also in terms of patent law. And he said that really the matter was a question of how patent law should treat claims directed to digital representations of physical objects and how patent law should treat claims directed only to physical articles where the alleged infringement involves only or primary digital renderings of the physical articles. And he also noted that really these issues had larger significance for other fields of intellectual property as well, particularly given the various different kind of conflicts that had taken place in relation to matters of copyright law. In the dispute before the Court of Appeals for the Federal Circuit, the International Trade Commission kind of emphasised its position that the Commission found that the digital models here really should be subject to its jurisdiction, and they were of the view that they should really be able to regulate what was happening. But they noted that there are a number of submissions by some opposing parties supporting ClearCorrect's concerns about how this would affect the internet more generally. It's interesting to see what happened in relation to the Friend of the Court briefs that were made in relation to this dispute. So the Motion Picture Association of America, the Recording Industry Association of America, the American Association of Publishers and Nokia all made submissions arguing that there should be a broad jurisdiction given to the International Trade Commission to regulate electronic transmissions. Those parties were very much concerned about larger questions in relation to intellectual property enforcement, and they were of the view that they needed to have the capacity to kind of make complaints to the International Trade Commission, particularly to deal with electronic commissions of copyright related to music and film. Some commentators really argued that really the copyright owners had been frustrated in their efforts to pass the Stop Online Piracy Act in the United States, and they were trying to find another means to achieve the same end by having the International Trade Commission intervene and kind of block access. By contrast, the Internet Association, the Electronic Frontier Foundation, Public Knowledge opposed the position of the International Trade Commission, and they kind of argued the International Trade Commission should have no authority to intervene in disputes in relation to electronic transmissions. They said that the jurisdiction should very much be focused upon trade in physical goods, and really it was a matter for Congress to decide whether or not the International Trade Commission should have an expanded authority. Surprisingly, the Business Software Alliance, which was set up by Microsoft and also then was joined by a number of other software companies, also supported reversal of the position of the International Trade Commission. The Business Software Alliance said that it was easy to bring actions in courts in the United States if there was an issue about intellectual property. There was no need for the International Trade Commission to have such a central role in terms of regulating electronic communications. In the end, the Court of Appeals for the Federal Circuit was of the view that the jurisdiction of the International Trade Commission did not extend to electronically transmitted digital data. Justice Sharon Prost, for the majority, said, while Congress's intent regarding articles is unambiguous, it's worth repeating what we said in Bayer. Under these circumstances, we think it is best to leave to Congress the task of expanding the statute. If we are wrong in our interpretation, Congress is in a far better position to draw the lines that must be drawn if the product of intellectual processes rather than manufacturing processes are to be included within the statute. Concurring, Justice Kathleen O'Malley said, if Congress intended for the Commission to regulate one of the most important aspects of modern day life, Congress surely would have said so expressly. There was a dissent by Justice Pauline Newman, and she said that the Commission's ruling is consistent with the language, structure and purpose of Section 337 and decades of precedent concerned with digital data, electronic transmission and infringing importation. And she was very much of the view that the regime needed to be adapted to modern developments in relation to information technology, e-commerce and 3D printing. So that was a really interesting ruling. It hasn't stopped conflict from taking place between ClearCorrect and Align Technology. That has continued within the United States Patent Office and in the courts. Align Technology has been busy challenging ClearCorrect in terms of some of its patents, and ClearCorrect has been pushing for re-examination of Align Technology's patents. Align Technology has used the International Trade Commission as a jurisdiction in terms of other disputes as well. So I think that case study is really important to think about, and it has kind of larger ramifications for how different nations deal with innovation policy and how international institutions regulate intellectual property and 3D printing. There's been a lot of debate at the moment in terms of some of the large implications of the trade war between the United States and China, and that has kind of tapped into a larger discussion about intellectual property, 3D printing, and the offshoring and onshoring of manufacturing. Geographers like Thomas Birchnell have really been interrogating the argument that 3D printing will transform the way that we do trade, and he's been kind of thinking about to what extent can 3D printing really enable developed countries to bring back manufacturing or enable there to be new hubs of manufacturing rather than such sites of manufacturing going offshore. Attorney John Hornick has kind of noted that there are larger geopolitical tensions between nation states in terms of their innovation policies around intellectual property and 3D printing. The United States and many members of the European Union have invested heavily in 3D printing and additive manufacturing and advanced manufacturing. But at the same time, China has also been investing heavily in a range of emerging technologies, including 3D printing. So at the moment, some of the larger tensions between the Trump administration and China have really been about intellectual property and innovation policy and trade. It's just worthwhile kind of picking up the way in which the US government has thought about the importance of 3D printing. So there was a very concerted effort by the civil society group Public Knowledge to better inform policymakers in the United States about 3D printing, and they held events like 3D DC in Washington DC to try to get inventors of 3D printing and companies engaged in 3D printing to engage with the policymakers. As a result, in the United States Congress, a Maker Caucus was established of committed politicians who wanted to promote 3D printing to boost innovation, education and manufacturing. President Barack Obama then sought to adopt and apply 3D printing in terms of some of his policies around education, innovation and manufacturing. And America Makes in particular was a concerted effort to try to have a public-private partnership to boost collaboration and cooperation on 3D printing and additive manufacturing in the United States. And it very much was kind of driven by a larger concern to boost the advanced manufacturing capacity of the United States, particularly in some of the depressed Midwest regions of the United States. Trump, as president, has produced an American first approach to trade policy. And that has involved a number of different elements, including taking trade action against China and the World Trade Organization, calling for the World Trade Organization to be reformed, pulling the United States out of the Trans-Pacific Partnership, calling for a renegotiation of the North American Free Trade Agreement, which has now been put forward as the United States-Mexico-Canada Agreement. There has been a lot of debate about the impact of Trump's trade policies upon 3D printing. Some, like Joshua Pearce, have argued that really the trade war between the United States and China is an opportunity to encourage greater use of local, distributed, homegrown manufacturing, particularly utilising 3D printing and additive manufacturing. And in the face of economic conflicts, he argues that that will be the best way to deal with those concerns. However, a number of 3D printing industry leaders have been concerned that trade tariffs in particular have had an inadvertent negative impact upon 3D printing activity. So computer security researcher and hacker Andrew Bunny Huang has been highly critical of the United States Trade Representative's decision in respect of tariffs. And he said that the tariffs tax the import of basic components, tools and sub-assemblies while giving fully assembled goods a free pass. And he argued that the tariffs would have a counterproductive effect on the 3D printing community. Likewise, Cory Doctorow, the digital rights activist, has argued that the trade dispute and the tariffs will have an adverse impact upon 3D printing education and teaching, particularly because it's very dependent upon components. Likewise, Christoph Mandy from Formlabs has said that if the intent is to boost manufacturing in the United States, the overall effect seems to be to support dispersed supply chains across East Asia instead, by having component supplies continue to be sourced in China and assembled in another low labour rate geography. At the same time, it should be said that there's a very complex picture at work in China. There's been a lot of concern about China engaging in a very systematic pattern of intellectual property infringement. The United States, as part of its trade action against China, has highlighted that. And there has also been action against Huawei in relation to alleged theft of trade secrets related to Tappy, a T-Mobile robot. But some of those concerns have also been apparent in relation to 3D printing. There's been sometimes concern that Chinese manufacturers have been using 3D printing technology in ways that might breach patents, trademarks, copyright or trade secrets. The FBI has kind of complained that in some circumstances it's very hard to tell the difference between an authentic product and super fake made by 3D printing. And as noted by the United Kingdom Intellectual Property Office report by Angela Daly and others, China has been pursuing the Made in China 2025 policy as a key strategy and has been investing heavily in artificial intelligence, big data, mobile internet and the Internet of Things. There's been a very heavy pattern of investment in intellectual property related to 3D printing and additive manufacturing. So there are going to be huge tensions there in relation to what is happening in relation to intellectual property and 3D printing in the context of trade. It has not only been the United States and China who have been positioning themselves for innovation leadership in relation to 3D printing, additive manufacturing and advanced manufacturing. Canada has adopted a new policy under Trudeau of supporting regional superclusters of innovation, and particularly in the province of Ontario, the Canadian government has heavily invested in advanced manufacturing, including in 3D printing. Professor Michael Geist from the University of Ottawa has argued that we need to better align intellectual property policy and innovation policy in Canada to support the supercluster policy. And in particular, he has argued that there needs to be reforms to intellectual property to help assist Canada obtain a leadership position in relation to advanced manufacturing. The European Union has also got notable strength in 3D printing, additive manufacturing and advanced manufacturing. Germany in particular is a real focal point for activity in relation to 3D printing, but a number of other countries like France and the Netherlands have also invested heavily in relation to 3D printing. The European Parliament has issued an interesting 2017 policy guide looking at intellectual property, 3D printing and regulation. Furthermore, Markus Norgaard and his colleagues in Finland have kind of produced a really interesting collection looking at all the various dimensions of intellectual property and 3D printing in the European Union. It's been noticeable that some European countries have had very similar concerns to those of the United States in terms of some of their dealings with China. So Germany's innovation policy is being updated to try to stop foreign entities, particularly from China, from taking control of key companies in fields of emerging technology such as 3D printing and robotics. So there's some very interesting tactical movements taking place at the moment in terms of different countries' innovation policies. And Australia, for its part, briefly pursued an innovation policy looking at an ideas boom. But if you look at the intellectual property statistics, we're still struggling in many ways to achieve the same scale of investment in relation to 3D printing and additive manufacturing. But for states like Victoria and South Australia, there's a great interest in 3D printing, providing some sort of new wave of jobs to replace those that have been lost with the collapse of the Australian car manufacturing industry. Final part of my paper really looks at some of the responses of global institutions to some of these larger debates over intellectual property, 3D printing and trade. And I guess there are a number of different hypotheses in terms of what may happen in relation to the technology of 3D printing, but also in terms of how that will affect trade. So Gartner's hype cycle is a useful kind of portrait which tries to deal with what aspects of 3D printing have been overhyped, where has there been disillusionment in relation to some of the claims being made about 3D printing, and where is the plateau of performance in terms of productivity being achieved in certain forms of 3D printing. So there's a lot of discussion at the moment about what are some of the mature applications of 3D printing, and certain areas like metal 3D printing and bioprinting have come to the fore of late, while some of the earlier dreams of there being a 3D printer in every home and there being personal home 3D printers being widespread has kind of fizzled somewhat. The World Trade Organization has been very interested in how new technologies will affect the future of trade. The World Trade Organization report in 2018 provides a useful discussion about how electronic commerce, 3D printing, blockchain and artificial intelligence will affect patterns in relation to world trade. The World Trade Organization kind of notes that 3D printing is currently used mostly for upstream global value chain activities such as prototyping, complementing traditional subtractive production processes. In the longer run, however, 3D printing may to some extent substitute for traditional manufacturing methods, reducing the need for outsourced production and assembly, the number of production steps and the need for inventory, warehousing, distribution, retail centres and packaging. Moreover, they kind of note that value chains in a world of pervasive 3D printing may not only become shorter with the emergence of production centres near every large customer base or near centres of innovation, but they might also look very different, being mostly based on the cross-border exchange of data in the form of designs, blueprints and software, rather than on the cross-border exchange of material goods and services. The World Organization observes that full realisation of the potential of 3D printing depends on overcoming a number of obstacles. The necessary material technology is still nascent and building complex objects is slow. There are also regulatory issues that need to be addressed before 3D printing is to be more widely adopted in the consumer market. They include product warranties, liability, attribution and questions about intellectual property. Finally, although it has declined in recent years, the cost of printers, materials and scans is still relatively high, especially for deployment in micro, small and medium-sized enterprises. And in the event of national conflicts over intellectual property and 3D printing, the World Trade Organization may of course play a role in resolving those disputes with its ability to arbitrate trade matters. For its part, the World Intellectual Property Organisation has sought to provide greater information in terms of intellectual property activity in respect of 3D printing. So in 2015, they did a study on intellectual property and breakthrough technologies, looking at 3D printing as well as robotics and nanotechnology. The statistics from that study shows the accelerating change in relation to 3D printing and the diversification of 3D printing. It's very noticeable as well some of the trends that have been taking place in relation to patent activity in relation to 3D printing. So there are development of patent thickets across a range of fields of 3D printing and subfields. We see a number of companies really dominating the area. So 3D Systems, Stratasys, Siemens, General Electric, Mitsubishi, Hitachi lead the patent filings. If you look at the statistics in terms of 3D printing first patent filings by nation and by applicant, it's very noticeable that certain innovation superpowers are really dominating the 3D printing filings in relation to patents. So the United States obviously remains a very significant player, as well as Germany, the United Kingdom, the Republic of Korea, South Korea and Japan. But as with many other statistics in relation to intellectual property of late, you see a huge kind of rise in the patent filings in China. The statistics are also kind of quite revealing in terms of who is actually filing the patents. We see a growing trend towards corporate ownership in relation to patents related to 3D printing, although there is very significant activity in relation to academia and the public sector. And I know your Dean, Professor Rooksby, has done kind of leading pioneering research on intellectual property and higher education. While higher education kind of led to a number of different breakthroughs in 3D printing, like the development of RepRap by Adrian Boyer, we really now see the commercial private sector kind of dominating some of the activity in relation to 3D printing. The OECD has also considered the next production revolution and has looked at some of the issues relating to intellectual property and 3D printing. It has also highlighted the need for thinking about some of the questions around sustainability in respect of 3D printing. So there's been a great debate about whether or not 3D printing is a clean technology or whether it's part of a junk economy. And the OECD report is very much focused upon how you need to align economic incentives and environmental laws to ensure that 3D printing helps promote a circular economy and uses sustainable innovations. It should also be noted that the World Economic Forum has been a great champion of 3D printing and has often had a very utopian vision of 3D printing being part of a fourth industrial revolution. Some of the members of the World Economic Forum have had some different views about the extent to which 3D printing will revolutionise trade. Klaus Schwab tends to be of the view that it will have a very revolutionary impact, whereas the head of logistics at the World Economic Forum is a little bit more moderate in his views, saying that really supply chains are affected by a wide range of different factors. It's not just the technology that is involved or the consumer behaviour. Global value chains involve a whole range of different factors. So in conclusion, in my presentation today, I really kind of highlighted how 3D printing will disrupt not only intellectual property, but also international trade law. I've looked at the case study involving the dispute between ClearCorrect and Align Technology, and I've noted that the International Trade Commission's effort to have a very expansive vision of its jurisdiction has been rejected. So its role is very much kind of confined to a traditional role in terms of looking at the trade of physical goods rather than digital data distributions. I've highlighted the way in which the trade war between the United States and China is impacting upon the 3D printing community. I've kind of discussed the kind of larger debate about to what extent will 3D printing halt the pattern of the offshoring of manufacturing away from developed nations to developing countries. And I've also kind of looked at some of the responses of some of the global institutions like the World Trade Organization, the World Intellectual Property Organization, the OECD and the World Economic Forum. So thank you very much for letting me participate in both the conference and the special edition of your law journal. And I wish you all the best in terms of your deliberations in relation to the conference. Thank you very much.